A very good afternoon to all. And again, welcome to another session of company laws. Yesterday's session, I hope you have liked and you have understood all the provision, whatever we have discussed in capital structure. It's an important chapter as far as your exams are concerned. And whatever we had discussed yesterday, whether it is transfer of shares, transmission of shares, maybe a owned capital, borrowed capital, or you can call it as what is the difference between members and shareholders. All are very, very important. So you have to understand all the provisions, whatever we had discussed. And we had started yesterday the another chapter also, which is winding up of companies. So winding up of companies, we had started and we had discussed that what is the meaning of winding up. And that is clear that when the company is going into liquidation process, because the company is created by law, you have given birth to the company with the help of law. So naturally, the company will not die a natural death. The company needs to die a death which is a legal one, which is a process of law. So we had discussed the definition that what is winding up when we close the company, then the liquidator will be appointed. He will collect all the assets, then he will pay off the debts, and whatever is remaining, that sale proceed will be distributed among the shareholders. And shareholders, yes, includes both preference and equity. So we had discussed about the meaning, and then we had discussed about dissolution also, that after the tribunal makes an order, then the tribunal, when a report is submitted by the liquidator, then the tribunal will form an opinion and gives an order of dissolution. Okay. After the order, when the liquidator will receive, what he will do, he will file a in petition, or you can say he will file an information with the registrar. The copy of that order he has to file. That means this now the company is going into liquidation and now the company is dissolved. So this is a legal proof. You have already received an order copy and you have submitted the same to ROC, and definitely he has to make that minute of dissolution of the company in his books. So that we had already discussed. I hope that is clear to you. Then modes we were discussing about the modes, and I think one mode I had discussed, if you have understood, there are two modes as discussed in the previous lecture: compulsory winding up and voluntary winding up. So compulsory winding up is known as winding up by the tribunal, when the tribunal makes an order that the company has to be shut down. That is compulsory. And another one is voluntary winding up, which will happen when the in a general meeting, the members will pass a resolution. And when the members will pass a resolution, they are passing a resolution voluntarily. Okay, that we had discussed. I hope two types are clear to you. That one is compulsory, which is by the order of the tribunal. Tribunal is NCLT. And one is that when the members makes or pass a resolution that we are going to shut down the company. Maybe what is the reason, that definitely we are going to discuss in that part. What is the reason and when you are going to close it, when you are going to begin with the proceeding of winding up. So they have to pass a resolution, and in that resolution they have to decide that we are now going to shut down the company. Then we had seen that in case of compulsory winding up, or maybe you can call it as winding up by the tribunal, who can apply for compulsory winding up or winding up by the tribunal. So following are the persons, any one of them can apply. That the company can apply, the creditors can apply, the contributories can apply, maybe a combination of these three can apply. They have given a choice that in place of applying separately or individually, it is better that you can come with the one petition and everybody will sign on it. So creditors, company, contributories, everybody will sign on it. Even the registrar and the person authorized by the central government can also apply for winding up process. Okay, these are the, you have to just remember that who can apply. So you have to be very clear that following persons can apply for winding up by the tribunal. Now, this also we had seen that what are the grounds for compulsory winding up. I hope all the grounds are clear to you and you are not having any doubt in any of the ground. Maybe some you can say are little bit difficult, but I don't find that any difficulty is there because it's very clear. In simple words, if you go one by one, first of all, if the company is unable to pay the debts, you have to go for compulsory winding up. If the company has passed a special resolution, that company be wound up by the tribunal. In the special resolution, it was decided that we are going to the court, and now the tribunal will say that yes, you will shut down the company. If the company is or has done anything which is against the sovereignty or integrity of the nation, then so definitely you have to close down. Okay, and maybe it is disturbing the friendly relations, maybe it is disturbing the foreign relations, and maybe you whatever you are doing, it is against the decency and morality. Even the tribunal will order on the winding up of the company if it is under revival and rehabilitation of sick companies. Whatever it is, that chapter 19, it talks about revival and rehabilitation of sick companies. So in this circumstance also, the court will order for winding up. And because you have seen that the registrar and the person authorized by the central government can also file the application for compulsory winding up, the tribunal will form an opinion and they will find it out that yes, if the company is doing any fraudulent business or if the company is running into an unlawful manner, then definitely the company has to be shut down. So it's very easy. Two things. Company is doing the fraudulent business just to cheat the shareholders if they are doing something, or they are using something which is unlawful, which is against law. So the registrar or any person authorized by the central government will put a petition to the tribunal that, sir, this is happening, this is the proof, and now we would like that you should start with an order for the compulsory winding up. Then if the company has made a default in filing with the registrar the financial statements and annual returns for the last 5 years, okay, so this is very simple, that the last 5 years, it is a duty that you have to fill and put all the things with the registrar, but they are filling in sending the financial statement and annual returns. So again, they are falling into this category that they will be shut down by the order of the tribunal. And lastly, which is common, and you can say it's a very general provision, that the tribunal, if the tribunal is of the opinion that whatever they are doing justice, and whatever they are doing, it is equitable. Equitable means it is for the betterment, it is for the equity, that the company should be wound up by the order of the tribunal. So they can also do this. So under these circumstances, you have to remember these are the circumstances under which the company can go for winding up process, and it is by tribunal. That's why it is known as compulsory. Then we had seen about the procedure also, and the procedure as such is very lengthy, because when we talk about theoretically, when you just learn something for your exams, then you can see that it's very simple and you have to write in a very simple manner. But when we actually go for the process, it's very difficult and a lengthy procedure. And definitely you have to go step by step, and you have to be very careful, because everything you have to do correctly in the eyes of law. So we had seen that first of all, a petition has to be filed in the court. Now, again, the same question, who can file? So you know who can file. The company can file, the creditors can file, contributories can file, all the three can together file, or the registrar will file, or any other person who is authorized by central government. So petition will be filed by any one of the person, or maybe jointly or together with any other person. Then you have to appoint a provisional liquidator. Now, I think here we had discussed when you are going to appoint the provisional liquidator and where you are going to appoint a company liquidator. And I hope that the difference between the two is clear to all. Provisional liquidator is appointed when you have presented the petition to the tribunal and the tribunal has not passed the order. Which order? Order of winding up. Okay. So during this time, you have to just see the time. A person is making a petition to the court, definitely the court will take some time to make and pass an order. Okay. So during this duration, you can say during this duration of filing a petition and passing the order by the tribunal, a person is appointed which is known as provisional liquidator. And then once the tribunal passes an order, okay, once the tribunal passes an order, then the same person will be converted into company liquidator. Might be, if it is okay, if it is the person is suitable as per the requirements, qualification and experience. Otherwise, you can replace him and appoint a company liquidator as per the qualifications, as per the need of the work, as per the time, and as per the legal requirement. Okay, so this is the difference, because you may ask that provisional liquidator once we are appointing and then we are appointing company liquidator, then what is the difference? There is a difference. During the petition period, when till the time the court will pass an order, provisional will take place. And when as soon as the tribunal passes an order of the winding up, then the company liquidator will be appointed. We have seen that there is a provision that if you have found that the liquidator has involved himself into fraudulent work or maybe any fraudulent thing which is going to impact the shares, impact the uh, you can say the belongings, impact the whatever sale proceed is going to be distributed among different stakeholders, then there is a provision that you can replace this person and just ask for the another liquidator to take his place. So there is, and there are, you can say, provisions which allow you to replace and remove the liquidator if you found that he has done something wrong or he has involved himself into some illegal practices. So in that circumstances, you can remove and replace the liquidator also. Then the winding up of companies. In case of winding up of companies, what is going to be happen? You have to appoint a committee also. What you have to appoint? You need to appoint a committee also. And in that case, the committee be will be with, maybe you can call some of the directors and make the committee, because they are the right persons to guide you in the right direction. They have run the company for so many years. They know in and out of the company and they are having a knowledge of everything about the company. So the committee is going to help the liquidator, the company liquidator. Okay. And the company, this committee will say that these are the assets, and they will prepare a list of assets, and they will prepare the list of shareholders, those who are eligible shareholders. Then they will prepare the list of debts, the creditors, the debenture holders, because these all the things which you need to get ready with that. Because once you have start selling the assets, you have to collect the sale proceed, and then you have to start into an ascending order in which you have to make payment for everyone. So you have to make the payment of debenture holders, you have to make the payment for creditors, you have to make the payment for preference shareholder, then you have to make a payment at the end for the equity shareholders. So everything you have to just discuss. The company liquidator will discuss, make a list, prepare a list, find it out who are the eligible shareholders, find it out how much is the debt which needs to be paid, how many creditors are there which are lined up, which are pending, how many debenture holders are there which are pending, and everybody you have to pay. Okay. Then the powers of the tribunal, as discussed, powers of the tribunals are same as any civil court have. So all the powers which the civil court have in this particular situation or circumstance, the tribunal will also exercise the same powers. So they will take your evidences, witnesses they will call, they will take the witness also, and they will just look into that like just a normal court do the process of moving ahead towards the judgment. In the same manner, they will take care of it. So powers of the tribunal are that whenever they are going to pass the order, they will just apply and use all the powers whatever are given to the civil. Okay, so they are having the similar powers, you can say. Now coming to the another one. This is also very, very important, because it is going to happen with the special resolution, that as we had discussed yesterday also, that uh, voluntary winding up, because of the members, they are going to pass a resolution. And when they are going to pass a resolution, definitely they will decide that they want to shut down the company. And that's why it is known as voluntary. Now, as per the definition, it says that winding up by the members or creditors without any intervention of the tribunal is called voluntary winding up. See, the definition is very straight and very clear. Winding up by the members or creditors. What it is saying? You are winding up the company with the help of or by the decision of the members and the creditors, and there is no intervention of the tribunal. So they are very clear that court is not going to intervene. And tribunal, you can use the word, the tribunal may not involve in this. They are not going to interfere in this, and only the members and creditors will pass a resolution, and that's why it is known as voluntary winding. In voluntary winding up, the company and its creditors are left free to settle their affairs without going to the tribunal. What is the next thing which makes a difference or creates a difference between the voluntary and the compulsory one? They are saying that the company in this situation, the company and its creditors are free to decide whether they want to continue the company or whether they want to shut down the company. Clear? In that, you are not deciding. You have to go to the tribunal because there are certain circumstances and you are falling in one of them. But here, nothing is happening. Nothing is going wrong. Still, if the creditors and the members decide that they would like to close the company, they want to settle the affairs, there is no need to go to the tribunal. They will decide themselves because they are allowed by law. They are free. Legally, they are free to do this. And that's why it is known as voluntary winding up. Now, what is the way and how it process, or what is the meaning? If the company in general meeting passes a resolution for voluntary winding up, what they are doing, they are calling a general meeting. And in the general meeting, what they are doing, they are passing a resolution. So where the fixed period by the article for the duration of the company has expired, this is the first situation, and the event has occurred on which under the articles of the company is to be dissolved. So they are giving you two situations, or you can call them as two circumstances. What is given to you? Two circumstances are given to you in which you are calling the general meeting, and in that you are passing a resolution. Resolution for winding up of the company. So first one is where the period expired, which is fixed and by the article of association of the company. Okay, and that period is expired. In that circumstances, you can go for voluntary winding up. So, for example, at the time when you have incorporated the company, okay, so you have made article of association because it's an important document with memorandum. Okay, in that you have fixed the period already in advance that we are going to run this company for next 10 years. Okay, so you have already decided in article of association you have mentioned, and that is the important document of the company which talks about the internal rules and regulation of the company. In that you have mentioned that the company will be in work or maybe in business till next 10 years, then we are going to close. And then now the 10 years are over. So this is the first circumstance. So you can say this is the first situation. You have already decided as per the articles that we are going to run the company, do the business for next 10 years, and then we are going to close it. Correct? And the time is there. So now you have to close it. And voluntarily you are doing because you have already decided. Correct? Second is the event has occurred on which under the articles the company is to be dissolved. You have already mentioned in the article of association that if this will happen, okay, the one event you have decided that, for example, if the company is going into losses for the last 3 years, this is an event. Okay, this may happen that the company is going into the losses, might be, but we will see that in case of loss, you cannot go to voluntary winding up, correct? Because the first provision is if the company is unable to pay the debts. So if the company is unable to pay the debts, then definitely you have to go for tribunal. You have to go for compulsory, voluntary. Then in such circumstances, any event you have decided that, for example, this will occur in the company. That may be any event. Okay. If this will occur in the company and this circumstance occurred in the company or situation comes in the company, which you have already mentioned in the articles of the company, that in such circumstances, we are going to dissolve the company. And right now, you are in the same situation, you are in the same circumstance, then you will start the proceeding of voluntary winding up of the company. For that, what you need to do? The company has to pass a special resolution. Now, a special resolution, why? Because naturally you need more than 90% of the members and creditors, shareholder, everybody, that they will say, yes, now close down the company. So you need the permission also now, because company belongs to the shareholder. Creditors are also invested the money. Debenture holders are also there. So you cannot go as per your vision will. You have to involve everyone, and then you will pass a resolution. And in that resolution, you will decide that we are closing. Now, when the commencement of voluntary winding up is there, a voluntary winding up is deemed to commence at the time when the resolution for voluntary winding up is passed. So this is a provision. And what does it mean? That what is the time at which you can say that we have started with voluntary winding up procedure? Commencement means we have begin with the voluntary winding up procedure. What is that time? So they are saying as soon as you pass the resolution. A voluntary winding up is deemed to commence at the time when the resolution for voluntary winding up is passed. So as soon as you pass the resolution, what you are going to do? As soon as you pass the resolution, that is the time when you can say that we have started with the proceeding. Because the provision is when you can say that the commencement of voluntary winding up is there. So whether the voluntary winding up commenced or not. So yes, it commenced, but question mark is when, at the time when the resolution is passed. As soon as you pass the resolution, from that point, you have or you are into the winding up process. Correct? Now coming to the another provisions. There are two things which before you go for compulsory winding up, you need to do. Okay, this is you can say compulsory. And what is that? First is declaration of solvency. This is must because unless and until the company is solvent, you cannot proceed with voluntary winding up. I hope till now it is clear to you that when you will go for compulsory winding up and when you will go for voluntary winding up. So if you remember, the first provision of compulsory winding up says if the company is unable to pay the debts, where you need to proceed? You need to proceed for compulsory winding up and you need the order of the tribunal. Correct? Here, because you are using the second way of winding up, which is the second way, voluntary winding up, where the members and creditors are deciding that yes, the company has to be closed. Okay, so in that circumstances, what you need to do? You need to prove that your company is solvent. Company is solvent means that the company is having that much of money in that much of money which can easily pay the debts, which can easily pay the debts of the company. Correct? That then only you can say you are solvent. Then you can say that you are solvent. You are having a debt on you and you are having a capacity that you can pay the debt. Correct? So company has to prove because you are going for voluntary winding up. If the company fails to prove that the company is solvent, then you have to stop the voluntary winding up procedure and you have to choose the compulsory winding up procedure because if the company is not solvent, it is shown, it is proved that the company is or has to be wound up by the tribunal because the company is unable to pay the debts. Company is not solvent. So in this situation, when you are proceeding for the voluntary winding up, this is compulsory. This is a legal provision. It is mandatory. You have to prove that your company is solvent. Now, how are you going to prove that? The directors in the board meeting make a declaration verified by an affidavit to the effect that they have made a full inquiry into the affairs of the company and that having done so, they have formed the opinion that the company has no debts or that it will be able to pay its debt in full from the proceeds of assets. Now, what is happening? What is the provision? What is the law? The law is directors have to call a board meeting. Okay. And in the board meeting, they have to declare and declaration has to be on the affidavit. Correct. So directors are calling the board meetings. In that, they have to declare on affidavit that they have made a proper investigation. They have made proper investigation about the company's affairs or about the affairs of the company. And they are of the opinion that the company is having no debts. This is the first point. Okay. What the directors are doing? What the directors are doing? They are calling a meeting. In that board meeting, what they are discussing? They are discussing that the company on the affidavit, they are giving a declaration. Now, affidavit is a legal paper. You are whatever you are saying on oath that everything is correct to our knowledge. And the first thing is we have decided, we have inquired, we have made an investigation that company is not having any debts. So that means you are free. You need not have to pay to debenture holders, creditors, or anybody else. You don't have any debts, correct? Second point is Even if the company is having the debts, company is capable to pay all the debts from the sale of assets. Clear? First point is the directors are declaring on an affidavit that after the investigation, we had formed an opinion that company is not having any debt. That is the first thing. Secondly, even if after investigation, if the company is having the debts, the company is in such a fine financial or sound financial situation that the company will clear all the debts from the sale of assets. Correct? These two you have to say on affidavit. Now, after the declaration of the directors, what next you need to do? Declaration must be made within 5 weeks immediately preceding the date of passing of the winding up resolution by the members. Now, when we just now we had discussed a provision when the voluntary winding up commences. So it commences at the time as soon as you passes the resolution, correct? When you have to make this declaration, there is a time limit you have to make this declaration. This declaration has to be made within 5 weeks. 5 weeks immediately preceding the date of passing of the winding up by resolution by the members. Okay, so whenever on which date you have passed the resolution for winding up, from that date within 5 weeks you have to do this declaration of solvency. Now, declaration must be containing that winding up is not to defraud any person or persons. So declaration also state or makes an statement that whatever we are doing, we are doing winding up. What type of winding up? Voluntary winding up. So if we are doing the voluntary winding up, it is not to cheat any person. Okay, it is not to have a fraud with any stakeholder. It is neat and clean. It is as per law. It is clear. So this also you have to put in the declaration. Correct? I hope these two are clear to you. Moving ahead, the declaration must accompany a copy of the reports of the auditors of the company and a statement of the company assets and liabilities as at that date. What else? What else the declaration must contain? What else? The declaration must contain the report of the auditor. Why the report of the auditor? Because it will show the true picture of your assets and liabilities. So when you see the balance sheet, correct? When you see the balance sheet, company's statement of the company's assets and liability is a balance sheet, correct? So once you see the balance sheet, you can see that assets are more and liabilities are less. So you can find it out now that the company is in a sound financial position because we have more assets than the liabilities as compared to liabilities, correct? So this report should also be presented, which report? Which is audited by the auditor, which shows the assets and liabilities on that date whenever you are doing this declaration. Then this declaration must also be accompanied by a report of the valuation of the assets of the company prepared by a registered valuer. What is that? One thing is you need to have that audited balance sheet with your declaration because you are proving that you are solvent. What you are doing here? After the resolution of winding up passed within next 5 weeks, what you are showing? You are showing that you are.
मैम
Yes, sir.
आपकी पीपीटी रन नहीं हो रही.
नहीं sir, I am taking this PPT only.
Okay.
Yes. So what you are doing right now, you are showing that the declaration of solvency, you are declaring that your company is solvent. How you are going to show that? With the help of balance sheet, which shows the assets and liabilities on that date. One thing. Second thing is you are putting one more report in this declaration. Which is that report? That report is given by the valuer who has valued the assets of the company and he has made the report. What does it mean? Have you understood what does it mean? Which type of report I am talking about? I am talking about the report which is made by the valuer who has valued about the assets. So he has given you that this your building is for 1 crore, your land is for 2 crore, your this furniture is for 50,000, whatever it is. So whatever assets you are having, there is a valuation of all the assets and it is given by a person who is a legal person again, registered valuer. It is not that any person can come and give you a random sum of money that, okay, I will buy the land in so much amount of money, building in so much amount of money, cars in so much amount of money. No. He is a government legal person, government employee, which is a registered valuer. He will give you a report and he will give you and quote the exact figure, whatever you are going to get when you are going to sell your asset. So these two reports must also be given at the time when you are declaring the solvency. So this is the first provision in case of winding up, which you have to complete, that you have to declare the solvency. Correct? Now coming to the next provision. In the next provisions, you need to call the meetings of the creditors. This is also very, very important because the members have decided that they are going to wind up the company voluntarily. So definitely, as a creditor, I feel that because they are going voluntary winding up and might be they will not pay me or might be they will not return my money. So definitely it will come in anybody's mind that now because there is no intervention. You have seen in voluntary winding up, there is no intervention of the tribunal and the members are free to decide that they are going for voluntary winding up. Correct? In that circumstances, anybody can feel that the company is unable to pay my money. And what is that? Everything is related to money only. So you need to, after the declaration of solvency in the directors BOD meeting, one more thing the directors have to do. What? They have to call the meetings of the creditors. Okay. What they have to do? They have to call the meetings of the creditors. Now the meetings of the creditors, maybe you can call on the same day or the next day. So whenever you are declaring the solvency, maybe the board of directors are all available on the same day. Once you complete your BOD meeting, you can give the time to the creditors on the same day. That's how we are organizing a creditor meeting. Please join. This is a venue. This is a place. This is the time. Like you know what are the rules of giving the notice. We have already studied in meetings chapter. Correct. So either you can call on the same day when you are giving this declaration, if it is possible. If it is not possible, you can call the meeting on the next day. Correct? So when you are calling the meeting, we have already discussed the meeting chapter, what you need to do. I think everybody knows that what you need to do. You need to give a notice of the meeting. Correct? So notice of the meeting when you are giving, give the notice of the meeting, send it by registered post. You know the ways also, the methods also of sending the notices. A list of creditors with the estimated amount of claim. This you need to prepare. That means the directors need to prepare a list. So eligible, whatever eligible creditors are there, you need to prepare a list of all of them and put the name and against their name, put the estimated amount you need to pay. So somebody is having 1 crore, somebody is having 50 lakhs, somebody is having 10 lakhs, somebody is having 5 lakhs. Put the name and put the complete information that what is going to be paid to Mr. X, Mr. Y, Mr. Z, and so on. Then you have to prepare a full list of the creditors with their estimated amount of claims. After that, you need to make full statement of the position of affairs of the company, because the creditors, when they come for the meeting, they will say, show us the balance sheet. Only from the balance sheet you can identify that the company is capable enough to pay the debts. The company is having less number of liabilities and more number of assets, and that's why the company is in a sound financial position. So what next? You should be ready before you call the meeting. You need to prepare the full statement of the position of affairs of the company. So position of affairs of the company, in the layman's language, you can call it as a balance sheet. So be ready with the updated audited balance sheet because you are calling the creditors, correct? Then if 2/3 of the creditors consent that it is the interest of all the parties to wound up the company, it shall wound up voluntarily. Now what is happening? All the creditors are there. Today is the date of meeting. The creditors meeting is there, directors are there. They are what they are showing. They have shown the list and the estimated amount of claims. They have shown the balance sheet also. So whatever number is there, total, 2/3 of the total number. Whatever number of creditors are there in the meeting, 2/3 of that total number, if they give their consent, that it is for the betterment of all of us to shut down the company, to close down the company, then they will say, okay, go ahead with voluntary winding up. How many you need? 2/3 of the creditors, if they give their consent that it is in the interest of all the parties to wound up the company, it shall wound up voluntarily. Okay. Then if they are of the opinion that the company may not be able to pay its debt from the proceed of the assets sold, in such a case, they may pass a resolution to wind up the company by the tribunal. Now, there are two circumstances, or you may call that there are two situations. Okay, two circumstances or two situations. What are they? First is that all the total number, those who are present there, 2/3 of the total number will say yes to it after going through the balance sheet. And they will say, okay, we are giving our consent, go ahead for voluntary winding. But for example, if the creditors makes an opinion and they found through the balance sheet that balance sheet is not so sound, and we are of the opinion that even if you sell all your assets, the company is unable to pay our debts. What is their opinion? They are forming an opinion after going through the balance sheet that assets are not in such a good position. Even if the company sold all the assets, they are unable to pay our debts. Okay, so this is the situation in this meeting, that they are present, they are not ready to give their consent for voluntary winding up, and they are of the opinion that, sorry, as per the balance sheet, it is shown that the company is not having a sound financial position of the assets, and that's why what we are going to do, we will not give our consent. Okay, and whatever assets you have shown in the affairs of the company, statement of affairs, then they are not so much that they can, after the sale proceed, we will get our money back, or they are capable enough to pay our money or to pay our debts. Okay, so what they will do, again in the same meeting, which meeting right now we are having? We are having the meeting of creditors. In the same meeting, they pass a resolution in which they pass that the compulsory winding up procedure will be started. What does it mean? That the procedure should be winding up by the tribunal, not voluntary. In the creditors meeting itself, the creditors are passing a resolution that the company will be wound up by tribunal. Why? Because they have formed an opinion that the assets of the company are not so that they can repay our debts. So this is the another clause. Now, after, if they form this type of opinion, because they can do two things. Either two-thirds of them will give their consent easily and they will say, okay, go for voluntary winding up. Otherwise, they will say no to the voluntary winding up and pass a resolution for compulsory winding up. So creditors can do two things in the meeting. If they do this, that they pass a resolution of winding up by the tribunal, what the company has to do? Company shall file an application before the tribunal within 40 days. What the company has to do? Company has to file a application before the tribunal within 14 days of the creditors meeting. So 14 days, within 14 days, you can give the application to the tribunal that, sir, we have called the creditors meeting on this day, and these many creditors were present on the meeting, and they have decided, they have passed a resolution that the compulsory shall be, that winding up should be started, or the company has to be wound up by the tribunal. So you have to give all the details and all the proofs that you have called a meeting and this was decided. Company shall give the copy of any resolution passed at a meeting to the creditors, to the registrar within 10 days of such resolution. So because you have called this meeting of the creditors, naturally you have decided something. You have decided something. What you have decided? You have passed the resolution. Which resolution? That the company will be wound up by the tribunal. Okay. So this resolution ki copy, you have to give it to the registrar within 10 days of such resolution. So two things you are doing. Within 14 days, you are filing an application to the tribunal for compulsory winding up. Within 10 days of the creditors meeting, you are sending a copy of this resolution which is passed at the creditors meeting to the registrar. Now, this is a mandatory provision. This is not that by your wish and will you can do whatever you want. No. So what you need to do, you need to give this resolution copy to the registrar also, that, sir, we have called the creditors meeting on this date, this is time, and they, after going through the statement of affairs of the company, they formed an opinion that it is better for everyone that the company will be wound up by the tribunal. Correct? And the company will be wound up by the tribunal, and that's why they have passed a resolution. This is a resolution copy. and we have already applied to the tribunal. So you have to remember the days, number of days. Within 14 days, make an application to the tribunal. Within 10 days, submit a copy of resolution to the registrar. This is very important. Whenever you see any date, number of days, okay, that those are very, very important things which you have to remember, that in how many days you have to do, in how many months you have to do, whatever is there, you have to remember how many members, that means how many creditors consent you want, and 2/3, you remember that 2/3 should give their consent in a positive manner. Okay, so this is the procedure of voluntary winding up. This is the procedure of voluntary winding up. What you need to do for voluntary winding up, first of all, you need to declare the solvency. What you need to do next, you need to call the meetings of the creditors. Correct? So this is all about the winding up chapter. I hope you have understood the winding up chapter and you don't have any query, any questions, because it's very simple. Only you have to go through the provision, and I have made it so simple in the presentation. There is no as such language which is very, very difficult, which is technical, which is legal, which will bother you. It's very easy. Even as compared to, because in compulsory winding up, you need to learn the grounds of compulsory winding up. There are as such, they have not given any grounds. They are saying if it is made for a specific time period and the time is over, then you dissolve the company. If in the articles of association you have mentioned any event and that event has occurred, then also you can shut down the company. And you can go for voluntary winding up. Voluntary winding up may only you need to remember two provisions. One is declaration of solvency and another one is meeting of creditors. Nothing more you need to learn. One more thing you can do, you can learn at least 10 powers of the liquidator. We have seen now company's liquidator you are appointing, because once the order is passed by the tribunal, the liquidator will take charge of the company and directors are removed. So this only you can do, that you can learn at least 10, minimum 10 powers of the liquidator, that what types of powers he holds, what he can do in the company once he take charge of that. So this you can do. Okay. I think rest all I had discussed, and this you can say is the complete syllabus, whatever is there for the discussion. This is the last chapter, winding up of the companies. Okay. And one more thing, I'll just tell you that what you need to prepare, you need to prepare a short note on Securities and Exchange Board of India. Okay, that you can prepare from directly from the website of SEBI. Go to the website of SEBI and just read about SEBI. That is the answer. That is your answer. When you see the website, that is your answer about SEBI. Okay. And then you can go through the functions of SEBI. Those are also given on the website itself. Okay. So you can see what is SEBI, when it came into existence, and what are the functions. That is important, that what are the functions of SEBI. So that you can learn what are the functions of SEBI. Secondly, what you need to learn, I hope many of you are doing the trading part. They know how to buy the shares and sell the shares online, and maybe some of you are having the demat account also with you. So they are very well versed about that demat account. They know what is demat account and how you convert your physical shares into the electronic shares, which make it easy to buy, easy to sell. That demat account is connected to your bank account. Whenever you buy, the amount is debited directly from your bank account. Whenever you sell, the amount is directly credited to your bank account, whatever is attached to the demat account. Correct? So what you need to prepare, you need to just prepare what is a demat account. Okay, and what is the procedure of that? So what is that account? How you, it's a general account which you can open in any bank so that you can trade in shares. If somebody likes to do the trading, buy the shares, sell the shares, and they know how to do it, because it's a difficult task. Everybody is not capable enough to deal in shares. But if some of you are interested in dealing with the shares, then you have already studied the capital structure part. You should register yourself, you should go through it and make a demat account, buy one share, two share. Just try it, okay, whether you can go for it or not, and might be you can understand the procedure and then you can go for the trading part. So these are the two things which you need to learn more. Apart from that, we had discussed all whatever is there in the syllabus. Only the SEBI part, about SEBI. Secondly, what are the functions of SEBI that are important? Okay. Then what is a demat account? and what is the procedure of opening of demat account. That also, because some of you, those who are dealing in that and doing the trading part, that they don't know how to open it, and you can write that answer in your own words. So not a big deal. But those who are not having an idea of demat account, you just go through it. What is a demat account? Okay, and demat account mein how you are going to open it? What are the documents which are needed to open the demat account? So this much is remaining that you should learn. Otherwise, we had completed all the syllabus, all the chapters, all the important units I have already discussed. All provisions, I hope the provisions of companies management, companies meeting, dividend, winding up of the companies, and introduction of the basics of the company, National Company Law Tribunal, National Company Law Appellate Tribunal. I hope all the provisions are clear to all of you. And nothing is there which is very difficult. No, nothing is there. If you go through all the sessions, you can find it out that all the sessions are very easy. You can understand well, and naturally the PPTs are shared already with you. You can go through the PPTs, find it out, and you cannot find any problem. Everything will be easy for you, and you can do good in your exams. Okay, so all my best wishes are with you. Just achieve and attain good marks in your exams, and just go through the sessions, learn properly. All provisions where the dates are mentioned, the days are mentioned, those are very important. So you need to prepare those. Just now we had finished with 14 days and 10 days. So you must know that in case of voluntary winding up, 14 days after the date of declaration, you need to file a petition in the tribunal, and after the creditors meeting, within 10 days, the company has to submit the past resolution copy to the registrar of companies. So the dates, wherever you find the dates, and in NCLT also, in NCLT also, there are number of days, number of members in the tribunal, and then their qualifications, okay, qualifications of the president, qualification of the chairperson. Those all are things which are important for the exams. So please go through it, and just read all the provisions carefully. I had discussed the basics also. I had discussed the company's management, including the directors, appointment of directors, then auditors, appointment, removal of auditors, removal of directors, company secretary, everything. What are the powers of company secretary? That also. Then meetings may we had discussed about different types of meeting. What are the basic provisions which makes the meeting valid? That we had discussed in detail. Each and every provision is very important. You have to go through all the provisions. Okay. Then what are the different types of meetings? Annual general meeting is there, extraordinary general meeting is there, board of directors meeting is there. You have to remember how many days notice you have to send for different types of meeting. This is again very important, because for different types of meeting, the number of days for the notice are different. Okay, so that you need to see. Annual general meeting, first annual general meeting, again there are dates. There are dates when the company can hold first annual general meeting and when the company can hold subsequent annual general meeting. Again, that is important. Okay, might be some of you remember right now also that how many months extension period will be given, whether the extension period is not given, under what circumstances, something like that. So please go through the provisions again. Then in the dividend also, which is again a very important chapter, please go through it. Please go through the dividend part also. Okay. Please go through the dividend part also. Dividend may we had discussed the meaning of dividend, what are the different sources of making payment of dividend. Then from where you are going to pay, the sources part, you have to learn everything. Okay, because there are three sources. Then in which form you have to give the dividend. Secondly, to whom you have to pay the dividend, whether you are going to pay the dividend in cash or kind. This is also another thing. When you are going to pay the interim dividend, then when you are going to pay the final dividend, who is going to decide the amount of final dividend, when the amount is to be decided. These are all important questions. When you are going to, who is going to decide the final amount, whether the shareholders can increase the amount proposed or recommended by the directors, in how many days you have to credit the account, dividend account, in how many days you have to make the payment of dividend, what is interim dividend, then if there is an unclaimed dividend, for how many years, that you have to remember. Then where you have to transfer, if there is an unpaid dividend, you need to transfer where. Okay, then you have to transfer it to the fund which is known as Investors Education and Protection Fund. I think I have already given you that exercise to do, that just find it out. What are the ways in which the fund is utilized? Okay, so there are n number of ways. You prepare only 10. Minimum 10 you prepare. Otherwise, there are n number of ways in which the fund is utilized. I am talking about Investors Education Protection Fund. Only 10 you can prepare. That following are the 10 ways in which the fund is utilized. Correct? This you can do it yourself. It is an exercise for you. And after that, we had discussed about capital structure, which is a very, very important chapter. And you have seen that we had discussed n number of provisions there. N number of things, so many differences between we had discussed. Please go through it. It's very, very important. Okay. About the capital structure, about different types of share capital, different types of shares, different types of debentures, different types of preference share capital. Okay. And what is the difference between so many important provisions, whether it is a borrowed capital, whether it is owned capital, whether it is debt or whether it is equity, whatever it is a transfer or transmission, member or shareholder. So many things we had discussed. And lastly, we had finished with the winding up of the companies. In that, I had discussed two modes, compulsory and winding, voluntary winding up. I hope both the ways are clear to all. And you are not having any doubt when it comes to winding up by the tribunal and winding up by the voluntary members or by the members and creditors when they pass a resolution voluntary without any intervention of the tribunal. So I hope that you have understood all the provisions. Now you may go through the provisions, previous sessions also, because some
Ma'am,
of the sessions. Yes,
मैम आप सिर्फ अभी एक्सप्लेन कर रहे हो
yes, sir. It's hardly 5 minutes left. Okay.
ओके ओके नहीं नहीं पीपीडी अभी भी नहीं दिख रही इसलिए
I
मैंने
have stopped the PPT because the PPT is over.
ओके ओके ठीक है मैम ओके कंटिन्यू
So what you need to prepare about the complete capital structure part. In whatever provisions I had discussed in the previous session, you have to go through that, go through the one by one provision, learn each and every provision. Okay, the question may be asked on any provision. So you have to go through the provisions, you have to find it out which provision is important, what are the dates, which is connected to how many days, how many months, whatever is there, you have to find it out. Then winding up way, we had already done everything. Discussion of voluntary winding up, discussion of compulsory winding up, about the tribunal, about who can apply for winding up, and what are the ways in which you can go for tribunal winding up, under what circumstances, ground, situation, anything you can call that. Okay. And voluntary, we had just discussed, right? So I think there will be no issue, there will be no query, and there will be no doubt to any one of you, because all the provisions are discussed in a very simple and layman's language. Very simple. Nothing is as such, you can say, call it as a legal provision or too many legalities are there. No. All provisions are very clear, very specific, and very simple. So please go through all the sessions and please just read it out, all the provisions, listen to the session carefully, and naturally the PPTs will be shared with you. You can go through the PPTs. Okay. So that's all about this session. And now I'm ending this session. So best of luck for your exams. Score good marks, and I hope everybody is going to score good marks because the syllabus is not so difficult. It's very easy. So everybody is going to score good marks. So best wishes from my side to all of you. Thank you. Thank you for the session once again. And it's really nice to teach you. And thank you for joining the sessions and listening to the sessions carefully.